Jobidon case, Section 11, H, Protection against Double Jeopardy, Crown Appeal of Verdict. Facts. Jobidon accidentally killed a man named Haggart during a fist fight outside of a hotel bar. The men had fought inside the bar, but had been kicked out and continued fighting outside. Although Haggart was bigger, and trained as a boxer, Jobidon landed one punch directly in Haggart's face, which knocked him unconscious, and he fell on a hood of a car. Before he noticed that Haggart was unconscious, Jobidon then punched him 4 times in the face. Haggart fell into a coma and died after being taken to the hospital. Both men had consented to the fight. The Crown charged him with manslaughter and had to prove the underlying crime of assault. The appellant was acquitted at trial, because the Crown could not prove a lack of consent, but he was convicted upon appeal. Issue: at what point can the court vitiate consent? Can one legally consent to non-trivial bodily harm? Decision: the appellant was acquitted at trial but convicted upon appeal. Reasons: Jobidon argued that the underlying offense of assault is not applicable because both parties consented to the fight, and assault must lack consent. Without this, he cannot be convicted of manslaughter. The court does not accept this. The court holds that the assault provision must be interpreted in light of the common law. Prior to amendment, the crime of assault was codified verbatim from the common law. As such, it was to be colored by common law limitations on the element of consent in assault. It was a principle of common law that it would be against public policy to allow fighting with the intent to cause bodily harm to be legal because the activity does not have enough social utility. Consequently, since intention to cause bodily harm was itself illegal in the common law, consent to fighting could not be a valid defense. Sopinka, in the minority, claims that the majority is attempting to create an offense where one does not exist in the code by applying the common law, intentional application of force with the consent of the victim. Ratio: person cannot consent to death, or to violent force in activities that do not have enough social utility. Even if you seemingly consent to a fight, you cannot consent in law to the other person causing you non-trivial bodily harm. Provision 11. Any person charged with an offense has the right, if finally acquitted of the offense, not to be tried for it again, and, if finally found guilty and punished for the offense, not to be tried or punished for it again. Similar provisions. The following instrument binding on Canada contains a similar provision, Article 14, 7, of the International Covenant on Civil and Political Rights. See also the following international, regional, and comparative law instruments that are not legally binding on Canada but include similar provisions, Article 8, 4, of the American Convention on Human Rights and the Fifth Amendment of the Constitution of the United States of America. A similar understanding of the term punishment should apply to both paragraphs 11, H, and 11, I. Harmony between S11, I, and H, is desirable as fairness in punishment underlies both provisions, RVKRJ, 2016 1 SCR 906 at paragraph 39, RV Rogers, 2006 1 SCR 554. The definition of punishment that has been developed in the context of SS11, H, and I, also applies when interpreting that term under Section 12, RV Boudreault, 2018 3 SCR 599 at paragraph 38. Note that the protection of Section 12 extends to treatment in addition to punishment, Rogers, Supra, paragraph 63. Section 7 of the Charter may also provide some form of protection against double jeopardy, R.V. Krug, 1985, 2 SCR 255, R.V. Nova Scotia Pharmaceutical Society, 1992, 2 SCR 606, R.V. Penn, 2001, 2 SCR 344. General principles against double jeopardy have long existed in Canadian common and statutory law. They can be expressed in the form of more specific rules which are applied differently despite their common origin. R. V. Van Rassel, 1991 SCR 225. Autrefois acquit, a person should not be convicted of an offense for which the person was formerly acquitted. As codified at sections 607 to 609 degrees Fahrenheit the Criminal Code, an accused must prove that the matter is the same, in whole or in part, and that the new charge is the same as at the first trial, or that it is implicitly included in that of the first in law or on account of the evidence presented if it had been legally possible at the time to make the necessary amendments without altering the nature of the offense. Issue estoppel, the Crown is precluded from relitigating an issue that has been determined in the accused favor in a prior criminal proceeding, whether on the basis of a positive finding or reasonable doubt. Only issues either necessarily resolved in favor of the accused as part of the acquittal or on which findings were made are estopped. R. V. Mahalingan, 2008, 3 SCR 316. The Kienappel principle, based on the broader principle of residential judicata, a conviction cannot be registered on a charge if there has been a conviction on another charge that was based on the same delict or cause. Kienappel v. The Queen, 1975, 1 SCR 729. The same delict or cause is involved where there is no additional and distinguishing element contained in the offense that goes to guilt. R. V. Prince, 1986, 2 SCR 480. The principle does not apply to offenses involving different victims. Kienappel, supra, Prince, supra. At least some common law or statutory rules against double jeopardy also would be enshrined under Section 11, H. See the example briefly indicated in the recent decision of R. V. Barton, 2019 SCC 33 at paras 47 and 178, discussed infra. However, caution must be exercised about any suggestion of an identity between these rules and Section 11, H. The Ontario Court of Appeal has stated, for example, that the rule in Kienappel continues to be subject to the dictates of Parliament, that a law providing for multiple convictions out of the same delict is not per se a violation of the Charter, and that the constitutionality of such a law depends on the specifics of its provisions and their application to particular facts. RVRK, 2005, 198 CCC, 3D, 232, Ontario CA, at paragraph 40. In Van Rassel itself the common law and statutory rules against double jeopardy were analyzed distinctly from Section 11, H, with the court observing that the application of Section 11, H, of the Charter must be determined by considering the wording of this Charter provision. The Supreme Court has indicated, without detailed analysis on this point, that 11, H, protections are distinct from the above noted rules. Canada, Attorney General, v. Whaling, 2014 1 SCR 392 at paragraph 39. Purpose. The purpose of Section 11, H, is to protect against double jeopardy. Whaling, supra at paragraph 33. Generally, the principle against double jeopardy prevents double punishment for the same acts, as well as the unwarranted harassment of an accused by multiple prosecutions. The criminal law power involves a supreme invasion of the rights of an individual and there is a basic repugnance against its repeated exercise. The principle is an aspect of the more general principle against abuse of process. Bremner, supra, at paragraphs 23 and 26, citing Cullen v. The King, 1949, SCR 658 and Rourke v. The Queen, 1978, 1 SCR 1021. The Supreme Court, however, has recently clarified that protection against double jeopardy under Section 11, H, can apply if a person charged with the offense is punished again for it, even in the absence of a duplication in proceedings. Whaling, supra. Analysis. 1. Threshold for application of Section 11H. The protection afforded by Section 11H can apply if a person who has been charged with an offense has been I. Finally acquitted of the offense, or 2. Finally found guilty and punished for the offense. 3 aspects of this threshold for application are discussed below. The subsequent section explains the nature of the protection afforded by Section 11H, once the right is engaged. I. Charged with an offense. To engage Section 11H, a person must at one time have been charged with an offense as required by the opening words of Section 11. For guidance on this term, please refer to the discussion under the General Section 11 heading. Section 11H, protection is related not to the moment the offense was committed or the acquittal entered, but to the moment at which an attempt is made to retry the accused, impose an additional punishment, or retrospectively increase the severity of the initial punishment. Therefore, even though the charter was not in effect at the time the proceedings began, it applies at the time the court has to decide whether it should order the holding of a trial which will infringe charter rights. Corps Professionnel des Médecins v. Thibault, 1988, 1 SCR 1033. 2. Two offenses the same. The two offenses with which the accused is charged or punished must be the same. They must contain the same elements and constitute one and the same offense arising out of the same set of circumstances. R. v. Wigglesworth, 1987, 2 SCR 541, Van Rassel, supra. Analogous offenses can be different for the purpose of 11H, if they are based on duties of a different nature, such as duties owed as a member of the public versus duties owed as a member of the RCMP, Wigglesworth, supra, or duties owed to the Canadian public versus duties owed as a member of the American public, Van Rassel, supra. Section 11H applies only to proceedings and not to legal enactments, and therefore does not prevent Parliament from creating offences that may overlap. Nova Scotia Pharmaceutical Society, supra. 3. Finally acquitted or finally found guilty and punished. If finally acquitted and if finally found guilty and punished mean that Section 11H applies after the appellate procedures have been completed. R. v. Morgenthaler, 1988, 1 SCR 30. In a criminal prosecution where the accused had already been subject to regulatory proceedings in relation to the same matter, it was found that the substantial monetary penalty imposed in the regulatory proceedings was not a true penal consequence, and so the earlier proceedings had not engaged Section 11 of the Charter. Therefore, the protection afforded by Section 11H of the Charter did not apply to preclude the criminal prosecution, because the accused had never before been charged with the offense for the purpose of Section 11, let alone finally found guilty and punished for it. R. v. Samji, 2017 BCCA 415, leave to appeal refused, 2018 SCCA number 27. An accused who is acquitted by a judgment containing no error is finally acquitted within the meaning of Section 11H. The fact that a proceeding is called an appeal is not sufficient to make it a true appeal. An appeal by trial de novo is actually a new trial disguised as an appeal. Thibault, supra. Section 11H. Protections arise only if a verdict has been rendered. However, broader protections against double jeopardy might arise under Section 7 even if there has been no verdict. For example, if a judge were to declare a mistrial in order to give the prosecution time to strengthen its case against the accused, or if the Crown were to enter a stay in order to preclude the jury from acquitting the accused, then Section 7 protections against double jeopardy might arise even in the absence of a verdict having been rendered. pen, supra, at paragraphs 113 to 114 citing RVD, TC, 1987, 38 CCC, 3D, 434, Ontario CA. 2. Nature of the protection afforded by Section 11, H. Effectively, Section 11, H, can be understood as providing protection against I. Being tried again for the same offense, 2. Being sanctioned again for the same offense, further to the principles and purposes of sentencing, and 3. Being subject to retrospective changes to the conditions of the original sanction for an offense that have the effect of adding to the punishment received, Whaling, supra, at paragraph 54. I. Being tried again for the same offense. This aspect of Section 11, H, is directed at preventing the state from making repeated attempts to convict an individual, Shubly, supra at 15. In other words, it precludes both, a. trying a person again for an offense that he or she has already been acquitted of, and b. trying a person again for an offense that he or she has already been found guilty and punished for, Whaling, supra at paragraphs 54, 56. To be precluded by this aspect of Section 11, H, the subsequent proceeding, tried again, must be a proceeding that is criminal or quasi-criminal in nature, Whaling, supra at paragraph 54. The common law double jeopardy rule preventing the Crown from obtaining an additional trial by advancing a new theory of criminal liability for the first time on appeal is also protected under Section 11, H, Barton, supra, at paras 47 and 178. 2. Being punished again for the same offense. See the Charterpedia entry on Section 11, I, for a discussion of the definition of punishment that has been developed under that right. As mentioned above, a similar understanding of the term punishment should apply to both Sections 11, H, and 11, I, KRJ, supra at paragraph 39, Boudrold, supra at para 38, Rogers, supra. In the absence of being charged with an offense, engagement of Section 11 rights is dependent on a person being subject to a true penal consequence, such as imprisonment or a fine of a sufficient magnitude, Wigglesworth, supra. See also the discussion under the general Section 11 heading. However, the concept of true penal consequence does not limit the ambit of punishment under Section 11, H, where a person has been directly charged with an offense. Thus, in the circumstances of actual offense charges, being punished again can extend beyond imprisonment and large fines, and would apply even, for example, to a small fine, Rogers, supra, at paragraph 63 and generally at paragraphs 56 to 63, see also the discussion of Whaling, below, on retrospective changes to the conditions of the original sanction. That said, punishment under Section 11, H, does not extend to every potential consequence of being convicted of a criminal offense. It does not extend, for example, to an order for post-conviction DNA sampling, which is no more part of the arsenal of sanctions to which an accused may be liable in respect of a particular offense than the taking of a photograph or fingerprints, Rogers, supra, paragraph 65, and does not have a significant impact on liberty or security of the person, KRJ, supra at paragraphs 53, 55. In this regard, the mere fact that consequences imposed for criminal conduct may have a deterrent effect does not make it a punishment for the purpose of Section 11, H. Courts have thus far found that a requirement to register as a sex offender does not amount to being punished again under Section 11, H, including because it is meant to provide police with an investigative tool rather than achieve sentencing objectives, R.V. Dyke, 2008 ONCA 309, 232 CCC, 3D, 450, see similarly under Section 11, I, of the Charter, R.V. Cross, 2006 NSCA 30, 205 CCC, 3D, 289 Leave to appeal refused, 2006 SCCA number 161. There is no doubt that a court may, without violating Section 11H, take prior convictions into account when determining the appropriate sentence. However, the fundamental principle of proportionality requires that the sentence be proportionate to the gravity of the offense and the degree of responsibility of the offender. A prior conviction cannot, therefore, justify a disproportionate sentence. This principle assures repeat offenders the right not to be punished, again, as guaranteed in Section 11H, R.V. Angelillo, 2006, 2 SCR 728 at paragraph 24. Similarly, facts underlying one offense can be considered as an aggravating factor in sentencing for another separate offense, albeit an offense arising from the same incident, without engaging Section 11H, R.V. LWT, 2008, S.J. number 75, Saskatchewan C.A. QL. Measures imposed by a court in response to a breach of a conditional sentencing order do not lengthen the existing sentence, nor do they impose a different sentence. In neither their purpose nor their effect are they double punishment, contrary to Section 11H, for the original offense, R.V. Casey, 2000, 141 CCC, 3D, 506, Ontario CA, leave to appeal refused, 2000 SCCA number 382. Provisions in mental health legislation allowing for involuntary admission, in other words, detention in a psychiatric hospital due to a risk to others or to oneself, do not involve the imposition of a punishment, for the purpose of Section 11H. Although protection of society is recognized as one of the legitimate aims of mental health legislation, such detention can hardly be considered punitive or penal in nature because it pursues dual and integrated purposes of promoting health and public safety. Nelson v. Livermore, 2017 ONCA 712 at paragraphs 127 to 129. 3. Being subject to retrospective changes to the conditions of the original sanction. Being punished again, under Section 11H, is not limited to the concept, discussed in Rogers, supra, of an additional sanction imposed in furtherance of the purposes and principles of sentencing. Section 11H, protections also can apply as the result of retrospective changes to existing sanctions. While Section 11H is not expressly concerned with the temporal application of the law, post-sentencing modifications of original sanctions may have the effect of increasing offenders' punishment, thereby engaging Section 11H. In this regard, Section 11H can protect against changes in parole eligibility under the Corrections and Conditional Release Act that are imposed on offenders already serving sentences. The dominant consideration will be whether the change frustrates a settled expectation of liberty on the part of the offender. Section 11H is clearly violated, for example, by retrospective changes to parole eligibility rules that automatically lengthen an offender's period of incarceration. Section 11H is less likely to be violated, however, if retrospective parole eligibility changes are not automatically applicable, but allow for an individualized assessment focused on the offender's circumstances, with procedural rights in the parole process being guaranteed. Whaling, supra. The provisions of the Corrections and Conditional Release Act that allow officials to place an inmate in administrative segregation in defined circumstances do not infringe Section 11H. The placement of an inmate in segregation pursuant to these provisions involves no change to the system of administrative segregation under the Act that results in changes to the length of an inmate's incarceration, and does not retrospectively frustrate the inmate's reasonable expectation of liberty at the time of sentencing. Canadian Civil Liberties Association v. Canada, 2019 ONCA 243 at paragraphs 142 to 143. 3. Relationship of Section 11, H. Protection with foreign proceedings. Section 11, H. does not apply to an extradition hearing since it was not intended to be given extraterritorial application so as to govern criminal processes in another country. An extradition hearing does not involve charges or a trial by the governments referred to in Section 32 of the Charter, R. V. Schmidt, 1987 1 SCR 500. Even if Section 11, H. could apply to an offense charged in Canada in respect of conduct for which a finding of guilt was made abroad, Section 11, H. will not necessarily apply if the offenses are based on duties of a different nature, such as duties owed to the Canadian public versus duties owed within the foreign jurisdiction. Van Rassel, Supra. Table of Contents. 1. Introduction. 2. The decision to appeal against an acquittal. 02.1. The Crown's right of appeal from acquittal is limited. 02.2. No appeal from an interlocutory ruling. 02.3. The public interest. 3. The decision to appeal against a sentence. 4. Initiating an appeal, the procedure. 04.1. Conceding appeals. 5. The Crown as intervener. 6. Appeals from summary conviction appeals. 1. Introduction. This guideline sets out the factors that must be considered in deciding whether to appeal an acquittal or sentence. 1. It also identifies who should make the decision to appeal on behalf of the Crown and the process for deciding. 2. The decision to appeal against an acquittal. The authority to appeal in criminal proceedings comes entirely from statute. Common law appeals against conviction or acquittal do not exist. 2. In Canada, even accused persons had no effective right of appeal until 1923. In 1930, an amendment to the Criminal Code, permitted Crown appeals against a question of law alone. While the basis for Crown appeals has since been further defined in the Code, essentially the Crown is still limited to raising legal, not factual, issues. At the foundation of criminal law lies the cardinal principle that no person shall be placed in jeopardy twice for the same matter, and the reasons underlying that principle are grounded in deep social instincts. This principle is reflected in S11, H, of the Canadian Charter of Rights and Freedoms, Charter. However, S11, H, does not preclude the Crown's right of appeal, as the words "finally acquitted" in S11, H, have been interpreted to mean after the appellate procedures provided in the Code have been completed. 3. Over the past 60 years, the courts have signaled the need to show restraint in exercising the right to appeal. Only cases where the public interest is best served by pursuing should be appealed. 2.1. The Crown's right of appeal from acquittal is limited. In indictable matters, the Crown's right of appeal against an acquittal is found in S. 676, 1a, which provides 676, 1. The Attorney General or counsel instructed by him for the purpose may appeal to the Court of Appeal. A. Against a judgment or verdict of acquittal or a verdict of not criminally responsible on account of mental disorder of a trial court in proceedings by indictment on any ground of appeal that involves a question of law alone. This is a much narrower right of appeal than that conferred upon a convicted person, who may appeal against conviction on any ground of appeal that involves a question of law alone, or, with leave of the Court of Appeal, on any ground of appeal that involves a question of fact or mixed fact and law, or any ground of appeal that appears to the Court of Appeal to be a sufficient ground of appeal, S. 675, 1a, of the Code. On an accused appeal against conviction, the court may allow the appeal if it concludes that the verdict of guilty was unreasonable, if the trial judge made an error of law, for example in an evidentiary ruling, or in the charge to the jury, or if there was a miscarriage of justice, S. 686, 1, of the Code. By contrast, the restriction on the Crown's right of appeal to a question of law alone means that the Crown cannot just complain about the verdict, or argue that the trier of fact rendered an unreasonable acquittal. 5 Justice Lamer, as he then was, explained as follows in Rousseau, 6. The trial judge considered that the accused guilt was not established beyond a reasonable doubt. I have read the evidence, and I believe that he did not, in so concluding, commit an error of law. Indeed, this is an appeal by the Crown from an acquittal, covered by S. 605, 1a, of the Criminal Code, which limits the appeal to grounds that involve a question of law alone. For the doubt entertained by the judge to amount to an error of law, it must be the result of conjecture and have no basis whatever in the evidence. Emphasis added. In addition to satisfying the Court of Appeal that a pure error of law led to the wrong outcome, the Crown must also show that the error, or errors, of the trial judge might reasonably be thought, in the concrete reality of the case at hand, to have had a material bearing on the acquittal. Point 7. 2.2 No appeal from an interlocutory ruling. There is no right of appeal to a provincial or territorial court of appeal from an interlocutory order or pretrial ruling. 8 Appeals are from verdicts. If there is no acquittal, or a judicially entered stay of proceedings, which for appeal purposes is the same as an acquittal, 9 The Crown has no right of appeal. Where the trial judge has made a pretrial ruling that for all practical purposes ends the prosecution, for example, a decision to exclude critical evidence under S. 24, 2, of the Charter, or a disclosure order with which the Crown cannot comply because it would breach informer privilege, the prosecutor may simply invite an acquittal or a judicial stay, and consider an appeal on the basis of an error of law in the impugned ruling. However, where the impact of the ruling is not so decisive, the prosecutor should continue the prosecution and await the verdict, as otherwise the prosecutor's decision to invite an acquittal in order to trigger a right of appeal may be seen as an abuse of process. 10. 2.3 The public interest. Not every unfavorable ruling or error in law should be appealed. Neither the judiciary nor the Crown has the resources to review every judgment that might be wrong. Still, the public expects and is entitled to a criminal justice system that is applied consistently and is effective in the suppression of crime. Where the dual thresholds for a Crown appeal against acquittal are met, 1. Error of law, 2. That in the concrete reality of the case materially contributed to the acquittal, the Crown will consider whether the public interest is best served by appealing the acquittal. Factors which may be considered when deciding whether the public interest is best served by an appeal include the following. 1. Is the issue raised by the case of widespread importance for the effective enforcement of the criminal law, or is its impact confined largely to the immediate case? 2. Does the seriousness of the offense or the circumstances of the offender demand a reconsideration of the case? 3. Have courts differed in interpreting the issue raised? 4. Could the trial decision impair the enforcement or administration of a significant government policy initiative, for instance, confiscating the proceeds of crime, reducing domestic violence, if left unchallenged? 5. Will the resources required to prepare and present the appeal significantly outweigh the value of pursuing the case further? 11. 6. Would the trial decision or decision to present an appeal have an impact on systemic racism, systemic discrimination, or the overrepresentation of certain groups in the criminal justice system, such as indigenous accused and victims? The application of and weight to be given to these and other relevant factors will depend on the circumstances of each case. A decision whether to appeal must not be influenced by any of the following. 1. The race, national or ethnic origin, color, religion, sex, sexual orientation, political associations, activities, or beliefs of the accused or any other person involved in the case, unless these factors are considered in the analysis of the decision's impact on systemic racism, systemic discrimination, or the overrepresentation of certain groups in the criminal justice system. 2. Crown Counsel's personal feelings about the accused, the victim, or the trier of fact. 3. Possible political advantage or disadvantage to the government, special interest group or political party, or 4. The possible effect of the decision on the personal or professional circumstances of those responsible for making the decision to appeal. 3. The decision to appeal against a sentence. An appeal against a sentence 12 need not be grounded in an error of law, S. 687 of the Code. However, the standard of review error in principle, or a sentence that is manifestly unfit nonetheless invites a court of appeal to give considerable deference to the sentencing judge, and the Crown should not lightly initiate an appeal against the sentence. It may be in the public interest to appeal where the trial judge erred in interpreting or applying a statutory provision or principle concerning the sentence, or where the sentence is clearly below the accepted range of sentences, not merely at the low end of the range, or where the sentence may set a negative precedent. The Crown must also consider how long it will take to appeal, and whether by then the offender will have served his or her sentence and deserves reincarceration. For initiating an appeal, the procedure. In general, the decision to initiate an appeal to a court of appeal is made by the Chief Federal Prosecutor, CFP, while the decision to initiate an appeal to the Superior Court can be made by the CFP or the Deputy Chief Federal Prosecutor, DCFP. This decision is made upon the written recommendation of Crown Counsel with carriage of the prosecution at trial or, where the trial was conducted by an agent, of the agent supervisor. The CFP or DCFP will consult with the applicable Regional Litigation Committee, and where appropriate the National Litigation Committee, before deciding. Crown Counsel may sometimes need to file a protective notice of appeal before consultations are completed and a final decision is taken about proceeding with the appeal. Protective notices should be the exception, not the rule, since counsel are obliged to bring significant adverse decisions to the attention of their superiors so that appropriate and timely action can be taken. Counsel should ensure that a final decision is made as soon after filing the notice as is reasonably practicable. Finally, Crown Counsel, including a legal agent, must not announce that an appeal will or will not be initiated until the decision has been made by the appropriate authority. 4.1 Conceding Appeals. The Crown is much more frequently the respondent than the appellant on criminal appeals. On rare occasions, appellate counsel may be placed in a situation in which an error of law committed by the trial court is so clear, or the findings of fact so patently unreasonable, that it may raise the possibility that the appeal ought to be conceded. This may arise, for example, in a case where a decision by the Supreme Court of Canada subsequent to the trial but prior to the appeal completely undermines the basis for conviction. The decision to concede an appeal or to concede on a particular ISSUE 13 within the appeal is never one that can be taken lightly. As a general rule, Crown Counsel's duty is to advance all reasonable arguments that may be made to support the decision of the court below, and to leave it to the appellate court to decide whether to allow the appeal. 14. Generally speaking, it is within the discretion of appellate counsel to concede on a particular issue in an appeal without conceding the appeal itself, where there is no reasonable argument to be made on that issue. Where that issue concerns the constitutional validity of federal legislation, however, instructions must be sought from the Office of the Director of Public Prosecutions, DPP, normally upon the advice of the National Litigation Committee. Where the issue concerns the constitutional validity of provincial legislation, consultation with the appropriate Attorney General's office is in order. Appellate counsel may also be called upon to exercise a discretion with respect to the admission of fresh evidence on appeal. The admission of such evidence is governed by the well-known four-part test consistently used by the Supreme Court. 15 Counsel may well choose to consent to the admission of such evidence where it raises a substantial concern about an offender's innocence. 16. Further consultations are necessary when counsel is of the view that an appeal ought to be conceded. Before making such a recommendation to the CFP, appellate counsel will seek the views of the trial counsel, and, where appropriate, the investigative agency. Where the concession is in a significant case, 17 consultation with the appropriate litigation committee will be necessary. 5. The Crown as intervener. Generally, only the parties to a criminal prosecution, Crown, and accused, may participate in an appeal before a provincial or territorial court of appeal. Interveners, when allowed, are generally not permitted to add to the issues in dispute, or to enlarge the record. In deciding whether to exercise its discretion to permit an intervener, the Court of Appeal will consider whether this will delay the hearing or resolution of the appeal, prejudice the parties including increased costs, whether the intervener has additional submissions to offer not already advanced by the parties, and the prospect of the appeal between the parties being expanded by the intervener's interests. 18. A recognized consideration that is relevant to the public prosecution service of Canada is whether it is desirable to have a national perspective on the issues brought into the appeal. 19. The decision to intervene in a provincial or territorial court of appeal is made by the DPP. The procedure for applying to intervene is the same as is explained in the PPSC Desk Book Guideline 3.16 Supreme Court of Canada Litigation. 6. Appeals from summary conviction appeals. In summary conviction matters, the accused may appeal from the adverse decision of a summary conviction appeal court, normally the Superior Court of Justice, to the Court of Appeal on any ground of appeal that involves a question of law alone, with leave of the Court of Appeal or a judge of that court, S. 839 of the Code. For many years in some jurisdictions the issue of leave to appeal was simply rolled into the main appeal, and was considered at the same time as the oral hearing of the appeal on its merits. 20. Leave to appeal to the Court of Appeal was routinely granted, whether or not the appeal on its merits was allowed or dismissed. In the 2008 judgment in RV.21, the Ontario Court of Appeal significantly reinvigorated the requirement of leave to appeal contained in S. 839 of the Code. Doherty G.A., writing for the court, reasoned that the requirement that the applicant obtain leave to appeal in S. 839 provides the mechanism whereby this court can control its summary conviction appeal docket. Access to this court for a second appeal should be limited to those cases in which the applicant can demonstrate some exceptional circumstance justifying a further appeal. 22. Justice Doherty went on to explain that leave to appeal to the Court of Appeal in a summary conviction matter may be granted, 1. Where the merits of the proposed question of law are arguable, even if not strong, and the proposed question of law has significance to the administration of justice beyond the four corners of the case, and 2. Where there appears to be a clear error even if it cannot be said that the error has significance to the administration of justice beyond the specific case. The courts of appeal in some other provinces and territories have moved in a similar direction. 23. Therefore, when Crown Counsel is facing an appeal to the Court of Appeal in a summary conviction matter, Counsel must consider whether to oppose leave to appeal by reference to the above considerations. In some cases, Crown Counsel will want to press the Court of Appeal to determine the issue of leave in advance, thereby avoiding an investment of time and resources responding to a groundless appeal. 24. The application may be made to a single justice, S. 839 of the Code.
Like this video, hit subscribe, hit that notification bell for more videos on Canadian law.